Contracts are a part of everyday life, but what happens when you need to get out of one? Whether it's a gym membership you no longer use or a business agreement that's no longer beneficial, understanding how to legally and safely exit a contract is crucial. We enter into hundreds, if not thousands, of contracts throughout our lives. It's not uncommon to find yourself in a situation where you're wondering, why did I agree to this? The good news is that not every decision is final, and there are several legal ways to get out of a contract. Let's explore some valid methods to terminate a contract. First, you can simply ask the other party to cancel the agreement. This straightforward approach can often lead to a mutually agreeable solution. Second, take advantage of cooling-off periods. The Federal Trade Commission provides a 3-day right to cancel certain purchases over $25 made outside a business's main premises. Third, review your state's consumer protection laws, as they may offer additional rights to cancel specific types of contracts. Before attempting to exit a contract, it's essential to determine if it's valid in the first place. A legally binding contract must have several key elements: an offer, acceptance, capacity to contract, consideration, intention to create legal relations, and free consent. If any of these elements are missing, the contract may not be enforceable. There are also legal grounds for terminating a contract. These include misrepresentation or fraud, where one party provided false information, duress or undue influence, where a party was pressured into signing, mutual mistake about a fundamental aspect of the agreement, breach of contract by the other party, impossibility of performance, or mutual agreement to rescind the contract. Many contracts contain specific termination or cancellation clauses. These may outline notice periods, penalties for early termination, performance conditions, or force majeure events that allow for cancellation. Understanding these clauses is crucial when considering how to exit a contract. When terminating a contract, providing proper notice is vital. Always review the contract for required notice procedures. Even if verbal notice is allowed, it's best to provide written notice to create a record. Clearly state the reason for termination and keep copies of all related correspondence. Consumer protection laws can offer additional ways to cancel certain contracts. The FTC's cooling-off rule allows cancellation of some sales within 3 business days. Some states have laws permitting cancellation of gym memberships, timeshares, or home improvement contracts within specified periods. If conflicts arise during the termination process, alternative dispute resolution methods like mediation or arbitration can often resolve issues without going to court. These methods are typically faster and less expensive than litigation. Force majeure clauses can provide an exit route when unforeseen events make contract performance impossible. These may include natural disasters, pandemics, or government actions. If your contract includes such a clause, review its terms carefully to see if your situation qualifies. In conclusion, while contracts are binding agreements, there are legal and safe ways to exit them when necessary. Always review your contract thoroughly, understand your rights under consumer protection laws, and consider seeking legal advice for complex or high-value contracts. Remember, the best way to avoid needing to get out of a contract is to fully understand its terms before signing. By being informed and cautious, you can protect your interests and navigate contract terminations successfully.